Good morning, Your Honour. If the court pleases, my name is Powell, initial A, and I'm the Crown Prosecutor today in this matter. Firstly, in today's proceedings, we are seeking a ruling regarding the competency and compellability of witnesses. Secondly, the Crown also seeks that Your Honour does not exercise the public policy discretion and allows the CCTV footage capturing the incident to be admitted into evidence. As Your Honour is aware, the competence of a witness is dealt with in Part 1, Divisions 1 and 1 Capital A of the Queensland Evidence Act, hereinafter referred to as the Act. Moreover, there is a presumption that every person, including children, are competent in accordance with Section 9 of the Act. Every competent person is compellable to give evidence, per Hoskin and the Metropolitan Police Commissioner. We turn firstly to Gareth and Lara at their joint trial, in which they are co-accused. Gareth and Lara are spouses and prima facie competent. Section 8, subsection 2 of the Act provides that spouses are competent and compellable to give evidence. While spouses are competent and compellable to give evidence, their status as co-accused here takes precedent. The case of Payne tells us that co-accused are not competent to give evidence for the Crown. As such, the Crown seeks separate trials for Gareth and Lara. This would see Gareth and Lara be competent and compelled to give evidence for the Crown. The Crown believes this evidence would be invaluable in finding the truth and delivering justice. The Crown now turns to Trent, who saw and heard the incident. As mentioned, every person, including children, are presumed to be competent to give evidence and to give evidence under oath, per Section 9 and 9 Capital B. Trent is 10 years old and therefore considered a child in accordance with Section 21 Capital A Capital D of the Act. As such, the principles for dealing with a child witness provided for in Section 9 Capital E are to be followed. Trent is considered an affected child due to the nature of the offence and his relation to the defendants under Sections 21 Capital A Capital C and 21 Capital A Capital D. His status as an affected child takes precedence over his status as a special witness. In the likelihood that my learned friend will seek to have Trent's competency examined under Section 9 Capital A due to his disability, the Crown turns Your Honour to the behaviours displayed by Trent. Trent was able to accurately recall details and communicated with investigators satisfactorily. This appears to meet the standards required under Section 9 Capital A subsection 2, where an intelligible recollection of events is deemed competent. It appears Trent has the capacity to understand and answer facts at issue in the proceeding. Expert evidence may also assist to further prove his competency, including Trent's intelligence, memory and perception. Expert evidence about a witness's ability to give evidence is admissible under Section 9 Capital C of the Act. The Crown also anticipates my learned friend may contend Trent's ability to give evidence under oath. While the Crown believes Trent to be competent under oath for the reasons previously mentioned, if Your Honour finds to the contrary, the value of the evidence submitted by Trent should not be decreased in accordance with Section 9 Capital D. An admissible statement may also be made prior to proceedings, provided for by Section 93 Capital A. Relevant provisions from 21 Capital A Capital E to 21 Capital A Capital X should be followed to mitigate the vulnerability of Trent as an affected child. Most notably, the Crown seeks that Trent's evidence be given by video recording, subject to Section 21 Capital A Capital K, and that limitations be placed on cross-examination, per Section 21 Capital A Capital H. Next, we turn Your Honour to Maud, who is the victim of the incident. As mentioned, every person is presumed to be competent and therefore compellable to give evidence. While the Crown anticipates the defence may challenge the competency of Maud, there is a distinct lack of information as to the state of Maud's cognitive abilities. However, on the available information, the extent of her condition appears to be just soft and slow speech. This does not appear to suggest that she is not competent to give evidence, as she still may be able to give an intelligible account of events which she has experienced, per Section 9 Capital A subsection 2. The Crown acknowledges that Your Honour may have doubts over Maud's cognitive abilities and welcomes any expert opinion Your Honour may wish to attain. Any expert opinion, of course, is admissible under Section 9 Capital C. Should Maud be considered competent, she is considered a special witness under Section 21 Capital A of the Act. This is, she is likely to suffer severe emotional trauma recalling the events. Further, if she is found to have a mental impairment, she would also be disadvantaged as a witness. Schedule 3 of the Act states that a mental impairment can be a cognitive impairment resulting in reduced capacity for communication. It's likely Maud fits this description. In accordance with Special Witness Provisions Section 21 capital A subsection 2c, the Crown asks that Maud may give evidence in a separate room to that in which the court is sitting. The Crown also asks that due to Maud's hearing disability, she be provided with an interpreter to assist in her communications per section 131 capital A. We now turn, Your Honour, to our last witness, Sally. Sally is competent to give evidence under section 9 of the Act and compellable per Hoskin. The Crown does not anticipate any challenge as to her competency as a witness. The Crown does acknowledge that during the incident, Sally was hidden under her bed and her vision was therefore impaired. She is, however, still competent to give evidence to the extent of what she heard, and this should be done under oath per section 9 capital B. While her evidence may be given lesser weight, this is for consideration by the Tribunal of Fact. The Crown now turns Your Honour's attention to the CCTV footage. The Crown anticipates the defence will challenge the admissibility of this evidence. As such, the Crown submits Your Honour should not exercise the public policy discretion provided for by Bunnings and Cross. While there was a deliberate breach of the Police Powers and Responsibilities Act to take the phone without warrant, the Crown argues that there are several key considerations for Your Honour, drawn from Justices Stephen and Aiken in the Bunnings case. Firstly, the data is of extremely high cogency, depicting the events that allegedly took place. There is also an argument for implied consent when Gareth indicated where the officer could find the data. While there was no indication that the evidence may be deleted imminently, the very nature of electronic data is perishable. As such, there's no guarantee that the evidence would still exist if the officer had not seized the phone. Further, grievous bodily harm is a serious offence, quantified by its 14-year imprisonment, and to exclude this evidence may result in a miscarriage of justice. Given the significance of the evidence and the gravity of the charge against the accused, the Crown submits that Your Honour does not exclude this evidence. Unless there is anything further, Your Honour, these are the Crown submissions.